Hi, everybody. Welcome to today's Affordable Housing and Real Estate Update. I am Nate Cushman. I'm an attorney here in Nixon Peabody's Washington, D.C. office. And I'm joined today by my colleagues Megan Altador, Ed Campbell, Harry Kelly, Forrest Milder, Kathy Soroka, and Steve Wallace. Thanks for joining us. We've got a great group. Before we begin, I'd like to quickly cover a few of the logistical instructions here. Today's call is being recorded. You will receive a copy of the recording and a thank you email following today's event. Expect that communication within the next couple of days. You may send questions to the presenters online during the presentation. On the bottom of your screen, you'll see a box that's titled Q&A. Please type your questions into this box and submit them to the presenters in that way. We will do our best to answer your questions during the webinar. If you're experiencing any technical difficulties during the webinar, please use the Q&A box to let us know about that. Can I get the next slide, please? I think there's one more slide. Very good. All right. So this is our disclaimer. The content in this presentation should not be construed as legal advice, and readers should not act on information in the presentation without professional counsel. Viewers and webinar attendees should seek advice applicable to their specific situation. The example clauses contained herein and other information presented hereunder are for educational purposes only. All right. Well, with that out of the way, we've got a large group and a lot of ground to cover. So let me turn it over to Megan Altador to jump right into the program. Megan.
Great. Thanks so much, Nate. As Nate said, I'm Megan Altador. I'm a partner at Nixon Peabody, and I have been spending my pandemic working on hotel acquisitions. So I'm going to speak to you today about distressed hotel opportunities for conversions into affordable housing. So hotel conversions present an exciting opportunity. While unfortunately COVID has frozen travel and brought the hotel industry to its knees in many places, it also means that there are possibilities for hotels to be put on the market, available at lower prices, and able to be repurposed to meet the needs of affordable housing. This is not to say the concept is brand new. Individual developers have been working on hotel conversions for some time, and I would categorize them by degree of difficulty. So the least degree of difficulty are conversions we've worked on where it's basically a hotel light. A residential property is operating illegally as a hotel. Perhaps it has a certificate of occupancy for residential use. But we've worked with developers to bring the property back into operation as residential and as permanent affordable housing, often combined with services and subsidy. A second category would be a conversion of hotels into transitional or shelter housing for adults or families experiencing homelessness. And again, in the nature of that type of rebuild, it's a much less intense rehab scope, and in some cases can require a much lower amount of approvals. But really what I want to focus on is this pandemic conversation we've been having, which is taking hotels that are operating in tourist areas, experiencing incredibly low vacancies, distressed, being put on the market, and as an opportunity for conversion to affordable housing. So in response to this opportunity, we've seen states and cities step up. They've been passing legislation and creating programs to provide fundings and mechanisms for hotel conversions. In Oregon, there's Project Turnkey. In California, there's Project Homekey. And now in New York, as of Friday, there's a new piece of legislation called the Housing Our Neighbors with Dignity Act that was just signed into law and hasn't yet figured out that it needs the word project in front of the name of the program. So I'm going to propose Project Honda, which is the acronym for the legislation, and we can see in a few weeks if that sticks. I want to talk a little bit about the challenges of hotel conversions before getting to the opportunities. I think the major challenge is a zoning and land use challenge. The fact that these hotels are zoned commercial in many cases, and they would require a costly and very time-consuming zoning process to be converted into residential. There's also the challenge of finding the right fit. Many of these hotels have small rooms. They're not conducive to adding individual bathrooms or kitchen facilities. So there are some real design challenges that are also very expensive, which is really the The third challenge is just the price of these acquisitions. There's certainly debate about whether this is a good use of government financing to be pouring money into hotel conversions. And we're already hearing that the market has picked up quite significantly since the beginning of the pandemic, with overseas buyers and hedge funds being interested in acquiring some of these distressed hotel properties. One other thing to mention is that affordable housing developers are used to using other people's money. They're not used to putting their own equity into deals. They're used to getting acquisition financing. So this is an area where it might not fit exactly into the box of what's available. And it might require some additional capital from the developer themselves. So these government opportunities and interventions are huge for that reason. So I don't want to leave you with the challenges. It's an exciting time to create some more housing stock, and an exciting time too to be using creative solutions. As of June, California has made 94 awards for 120 sites under their Project Home Key. And as I mentioned, there's this brand new program in New York that's very exciting, potentially bringing state funds to the acquisition of hotels and commercial properties. That law in particular has a number of restrictive parameters. It's geared towards nonprofit. It also has requirements for minimum amenities, such as a private bathroom and kitchen facilities. So those restrictions are going to limit the pool of eligible properties. It's going to limit the pool of eligible owners who can participate. But it's certainly a start and something interesting to look further into. So one other thing I want to mention is that all affordable housing developers are very creative to plug gaps using multiple subsidy sources, tax credits, and other financing mechanisms. So when a partner of mine, David Schoen, heard about this new hotel conversion program in New York, he mentioned to me that it's an exciting opportunity to also use historic tax credits. I know you'll hear from Forrest Milder later, and many other of my Nixon Peabody colleagues specialize in historic tax credit financing. In fact, it turns out that properties built as recently as 1971 can qualify for federal historic tax credit, and in many cases also state historic tax credit. And here in New York City, where I'm located, a lot of our projects that we're doing as public housing revitalization through RAD with the New York City Housing Authority actually qualify for federal historic tax credits, which is not what you would typically think of when you think about the public housing stock. So that's another creative way where you could leverage government financing to try to get some extra opportunity to create some additional housing stock and address the needs of affordable housing. So with that, I'm going to turn the program over to my colleague and partner, Steve Wallace, also known as the godfather of our affordable housing group, to speak to us about updates in the Biden HUD administration. Steve?
Great. Hey, thank you, Megan, and thanks everybody for participating today. We've got such a great turnout. And yeah, so we're off to a fast start. Many of the positions at the HUD have been filled. The HUD Secretary, Marcia Fudge, does not really have a housing background. She's more involved with rural housing, so not the same multifamily. But she's a former Congresswoman from Ohio, and she is certainly jumping into her position. But she's surrounded by very good people who come from the housing world. Adrian Todman, just within the last several weeks, was confirmed as the Deputy Secretary, with the number 2 person at HUD. And Adrian comes from a public housing background and brings a career worth of housing experience to her position. And she was very enthusiastic about her job, and again has surrounded herself with good people too. On the housing side, the FHA commissioner, Lopa Kalori, also comes from a public housing background, most recently as Director of Operations and Development at Philadelphia Housing Authority. But earlier in her career, she not only worked at HUD under Sean Donovan, but was in the private sector as well. At the multifamily side, the Deputy Assistant Secretary, which is a key position for many of you on this call today, Ethan Handelman is the Deputy Assistant Secretary and comes from the private sector as well as a trade and policy background. So Ethan has a broad experience, and it's not always the case. Oftentimes many of these positions are filled with political people who perhaps worked on the campaign, but in this case, we really have some qualified housing folks. The General Counsel, Damon Smith, worked at HUD during the Obama administration, and so he's back, and Dominique Bloom on the public and Indian housing side. So that's just a few of the key people that we work with at Nixon Peabody at HUD with regard to the public housing and family programs. But they come with a broad experience and a familiarity with the issues that are important to us. As with most new administrations, it takes a while for the president to propose his budget for the next fiscal year, and the Biden administration was no exception. Back in April, they unleashed their budget, and not surprisingly, it called for some rather large increases in FY 2022 for the HUD budget. So specifically, there was an overall budget increase of 15%, up to $68.7 billion. That's a big number for an agency like HUD, but it's really a number that's needed. Just some of the big increases went, the biggest program at HUD is the tenant-based voucher program, which the Biden administration increased or proposed at over $30 billion, which is more than a $4 billion increase. And that was hopeful of getting 200,000 new vouchers out to assist people to provide to find affordable housing. In addition, project-based Section 8 is now up to $14 billion. So when you look at the voucher program and the project-based Section 8 program, of the $68.7 billion proposal, $44 billion of that goes to the Section 8 program. So the voucher and project-based programs are critical for meeting the housing needs, but it does put a little bit of a crunch on some of the other programs. But Biden also proposed increases in public housing, the home program, and elderly and disabled housing. So for increases of new building and also energy efficiency. Now, once that budget is proposed, it's up to the Congress to actually implement and come up with their own numbers. And so the Senate really hasn't done much. The House, prior to their leaving for their August recess, passed many of the appropriations bills, including the bill for HUD. They didn't get up to $68 billion, but they increased the budget to $56.5 billion. And again, many of those programs that the Biden administration looked for increase in vouchers, project-based, Section 8, CDBG, also either got larger increases or actually got the same amount as proposed by the president. So some additional money went to Choice Neighborhood, which is a program that's bounced around at funding levels. The current year, it's $200 million, and the House proposed to increase that to $400 million. And of course, the home program has been on the rebound since about a decade ago when there were some issues politically with it, and it was down to less than $1 billion, and that's now approaching almost $2 billion. So, so the House has done their work. The Senate did not really tackle the appropriations bills, but prior to leaving, they did tackle infrastructure, which is, we were hopeful initially that the infrastructure would include housing issues, but unfortunately it doesn't. So it really stuck to the bread and butter of infrastructure: roads, bridges, electric grid, broadband is included, water, electric vehicles. That, for many of you who were watching the debate, it was interesting that the 19 Republicans joined all the Democrats in passing the bill, and by a 69 to 30 vote. So that's a $1.2 trillion bill, a big package, but again, no focus on housing issues. The Senate, again, before they left, did tackle the budget resolution. So these were broad instructions to the Budget Committee to get working on specific proposals, and each committee is assigned a specific dollar amount with instructions that come through the budget resolution. The budget resolution that the Senate passed was $3.5 trillion, a big number. And this is where a lot of excitement is, because broad instructions from Senator Schumer to all the debate chairmen include the creation and preservation of affordable housing, increases in public housing, CDBG, and general housing programs. Now, that vote was along party lines, so that was a much closer vote, 50 to 49. But the Senate left for their August recess and set the stage for coming back in September to tackle some of these issues, and so we can get a budget and appropriations. Whether that happens by September 30th or not, my guess is it will not be in time for the start of the fiscal year, which is October 1. You know, it has to be paid for, so the Finance Committee has to come up with tax increases. Of course, the Biden proposal do not want to tax anybody, any family making less $400,000. So those are issues that really have to be tackled once they return. The House is coming back early next week to begin work on some of these issues, including infrastructure. We'll see how that debate goes. Not everybody is on board. But before I pass the baton off to Ed Campbell, Senator Wyden of Oregon, the chairman of the Senate Finance Committee, he has not introduced, but he released portions of his new bill, Decent, Affordable, Safe Housing for All Act, last week. It covers, tackles homelessness as well as the affordability crises. Not only does it for credit issues, the expansion of the low-income housing tax credit, as well as the increases in the housing trust fund capacity building. So you can read about that, and a lot of the trade associations have a summary, but unfortunately I need to stop there so we can continue through this program. So a lot is going on in the housing world here in DC. And Ed Campbell, why don't you tell us what's happening in your world?
Thanks, Steve. So similar to Megan, about converting up hotels for various uses, I'm going to talk about another tool that is being used or can be used in order to sort of convert existing properties that are serving a homeless population to a better use or reallocating those funds. So I'll be talking about converting site-based projects under 15 or 20-year use restrictions without having to repay those funds. In order to better serve people experiencing homelessness, HUD is encouraging recipients of supportive housing program and continuum of care program funds to assess their projects to determine whether those funds should be reallocated or repurposed to better serve the homeless population in their community. Now, under both of these programs, the statutes under supportive housing and traditional housing, transitional housing, and permanent housing project that receive SHP funds for acquisition, rehabilitation, or new construction is required to operate the project for the period of 20 years for that purpose. Similarly, under the COC program, those projects must be operated for a 15-year period under their use restrictions. If the project is not used for these specified purposes for the 15 or the 20-year term, then under the guidelines of those programs, those funds need to be, that grant funds need to be repaid. Now, that brings up the next question of, okay, but HUD will allow exceptions to those. There are statutory exceptions to the use restriction requirements under both the COC and the SHP programs. HUD can approve a conversion of the property to another purpose that serves low-income and homeless persons, or an exception that will allow for the sale of the property. If approved, the recipient does not have to repay their assistance as long as the project is converted to an eligible use or the proceeds from the sale are used for homeless assistance. So when can a property be converted without repayment of the grant funds? HUD has expressly set forth 3 options under which the use agreement can be modified or removed, which I'll briefly discuss. However, this may not only be the only 3 options. HUD will also consider other options or alternatives on a case-by-case basis. So the first option I'm going to cover is the use of the property for a different approved purpose in accordance with that fiscal year's NOFA under the COC program. In some cases, a property with use restrictions associated with current COC program grants providing supportive housing services or operations may be converted to a different eligible use. So long as the remainder of the use period of the original property, is used for one of the permitted purposes which benefit persons previously experiencing, or at risk of homelessness. The recipients will not be required to repay the grant funds. The permitted purposes under these would be emergency shelters, permanent supportive housing, permanent affordable housing, health clinics and other outpatient health facilities, substance abuse treatment facilities, or day centers or facilities that provide social services to these homeless populations or those people at risk of homelessness. The use restrictions would continue, however, to apply to the building even under this new eligible use for the same period as it was originally intended for. The second option is to sell the property and invest the proceeds from the sale in a permanent housing project. If the property is not suitable for the purpose in which it was originally prescribed for under, say, an option 1, or one of those other options or eligible purposes under option 1, or if it's not needed for any of those purposes anymore, then another option is the property can be sold. Under the option 2, the requirements, the proceeds for the sale of the building would have to be used to expand or supplement one or more projects that provide supportive housing or rapid rehousing to people experiencing homelessness. Funds can also be reallocated to a new project in the COC, in the continuum of care, or reallocated to an existing project already operating in the continuum of care, regardless of whether that project previously received COC program funds. The sales proceeds from the sale of that property cannot be used to supplement another source for that property. And lastly, the proceeds from the sale of the property cannot be used to meet or the matching requirement under the COC program funded project. Then the last option that is expressly provided for HUD is basically transferring the existing use agreement from the original property to a new property that can provide those services to the community. Oftentimes, this option is really relied upon when you find the original project where this use agreement sits, that community, say, no longer needs those services in that particular area, or it can no longer really benefit that population the same way it once did. And so there's another property that may either be owned by that current owner or within the continuum of care area, generally, that can better serve that population. So if the property that originally received a new construction or rehabilitation funding many years ago is no longer suitable to continue serving people experiencing homelessness, the recipient may be able to identify another property that can be used for that project. In this case, the use agreement attached to the original property can be transferred to the new property for the remainder of the term of the use agreement. Now, this new property, there are certain conditions that new property must meet. It must meet any and all applicable housing quality standards under the COC program or the habitability standards under the SHP program. It must comply with any and all state and local code requirements. It must be in better condition than the original property where the use agreement sits right now. It must be able to serve at least the same number of people that the original property did. And lastly, it needs to be accessible and integrated into the community in which it's now being relocated to, in at least as much as the original property was at the time that grant funds were originally put in that original property. Now, as I stated, those three options aren't the only ones available to you. Of course, HUD will consider other opportunities on a case-by-case basis or other proposals. However, these are the ones most frequently used and more clearly laid out by HUD. Now, if one were to consider, conversion or take that upon, what really should they be considering? How do they undergo that analysis of doing it? And really things to think about if you'd like to consider converting your project are, one, how is the existing building being used? And is there a better area or use for that building under any of the options? What are the needs of the homeless population in your area? And also, what are the needs of the community surrounding that? And can they meet the needs of that homeless population, or would they be better served in another community or area? How have the needs of the community changed since the program was originally launched or the use agreement put in place? How would this conversion continue to meet the needs of the homeless population? And what would be the time frame for this conversion? After undergoing that analysis, if you think a conversion might be right to you, what's the next thing you do? The best thing to do is, one, you ultimately start with conversations between your continuum of care and HUD, and talk through the proposal or what you might want to do or how this would best serve the community, and sort of proceed from there. But this, like I said, this is actually another great tool to be used in order to better meet or better purpose the available funds or sources in a community to serve the homeless population better, particularly as we've seen sort of shifts in the community need, and both over the last decade with population changes and over the last year and a half during the pandemic, and how the needs of that population have needed to shift. And with that, I'm going to hand it off to my colleague Forrest to discuss income averaging and fixing the 4% tax rate.
Forrest, I think you're muted.
Sorry about that. This is in a lot of ways a continuation of the discussion we've had in prior sessions. I want to sort of bring people up to speed on what we're hearing from the IRS, what we are seeing people doing. The first thing I was going to talk about is income averaging. All of us refer to it as income averaging. I suppose if you want to sound like the cognoscenti, average income test, or AIT, has become sort of a cool way to describe this. So if somebody uses the phrase AIT to you, you'll know what they're talking about. You will remember that after income averaging became part of the statutory law, the IRS came out with its regulations saying how it should be done, and there was a fair amount of criticism of the IRS's interpretation. The code provision literally refers to whether or not you designate units which average out to 60% of area income, and the IRS incorporated a designated and occupied test. So they made it much harder by having you look at whether or not they are occupied as well. And notwithstanding a fair amount of input from the community, I personally wrote a letter full of examples. I sent them like 25 examples of how this should be done. There have been lots of people who have done stuff like that. the IRS to date has stuck to where they are. Now, sticking to where they are, of course, simply means that the regulations are sitting there and they haven't issued newer regulations. It is anyone's guess as to when new regulations will come out. There is no doubt that the IRS is aware of that issue, and I'll describe 3 more, that the IRS is aware of these issues. At the same time, people in their commentaries did a mix of critiquing the IRS's position and then also saying, well, we could live with this position, but you should fix this. So, it's at this point unclear whether the IRS will fix this and say you have to designate your units and then we'll worry about the occupancy, or if they will stick to this designated and occupied rule. Nonetheless, you will note that if you pick a number that is less than 60, if you made your units average out to say 55%, then even if you lose a couple of units, your average will creep up to 57, 58, and you could still be okay. Once you hit the 60% point, you're in trouble, because if you go above 61, you lose. And so the IRS offered in their regulations is 2-for-1 thing, in which anytime you lose a 40% unit, you could do an offsetting 80% unit, and the average would stay the same because 40 and 80 average out to 60. And so that technique was one of their techniques. People are not necessarily crazy about that, but that's a technique that's in the regulations that may change. A lot of people were worried about what to do with conflicts with other federal law or other local law. So situations where, say, the Violence Against Women Act really would require you to relocate somebody out of the unit they're in, at the same time as the IRS regulations require you to permanently designate a unit a certain percentage. They didn't really seem to have a flexibility for that. There's, I think, little doubt that they will fix that and that one will change, because that one just seems to make a lot of sense. And another thing that was highly criticized was the time to fix any problem. The IRS gave you a relatively short amount of time to fix any problems. People observed right away, gee, IRS, suppose I don't know I committed a problem and it turns up on audit that you take the position that I didn't do this properly. Now I'm well beyond the time. And so a lot of people suggested there's a similar provision for land use restriction agreements, which says that you have a year once you become aware of the problem. And, and maybe there should be something like that. I think the IRS has taken that seriously. So what we are looking at this point is a set of rules which can be hard to live with, and which have mathematical computations which are at odds with the statute, but again, people are, can manage to live with them. I would say that there is some notable portion of the investor community that wants to stay away from this. At one point, it might have been 1/3 to 1/2. I think it's less now. And I certainly hear from my colleagues in our syndication practice that there are, that a favored developer asks for a waiver on this issue. Can talk an investor into going along with income averaging, notwithstanding that the investor has otherwise told the world that they're not investing in income averaging projects. So it's worth asking if you're a developer. The second thing is, as I noted before, even though the test is at 60%, if you get yourself down into the mid-50s, you have a certain amount of room now, so that if a unit goes bad, if a few units go bad, you can still do the average and have the average come out to now be 58%, but less than 60. And as a result, you can still pass the test. Obviously, that's a bit of a waste. It was intended to be a 60% average, so to make somebody comply with a 55% average is a shame, but that's a possibility. And people are also asking for favorable guidance covenants, by which I mean that they put something in the documents which says that I will keep it at 55%, but if we get favorable guidance from the IRS that changes the rules, say along the ways that a lot of us are asking, that you'll let us go back to 60% low income and we won't have to overcompensate. So those are the fundamental things that are going on there. We are waiting guidance from on AIT. We don't know when we're going to get it. The IRS has heard us, but that doesn't necessarily mean that they'll change the rules. And at this point, more people are closing deals than used to, largely to the extent they are doing it largely by having a little headroom, by making the project be, say, 55% instead of average out to 55% instead of 60%, as a way to assure that they don't have something to worry about. And that is largely where AIT is. The other topic that I had was talking about 4%, the 4% credit rate. And you will remember that recent legislation gave us finally, after many, many years, a fixed 4% credit rate. The rate had fallen to about 3.1%. So this is really a very large increase, on the order of 0.9% on 3 so like a 1/3 increase based on where we were. And obviously a very desirable thing. Every developer looks at this and says, gee, is there a way for me to get it into my project, which is already closed, which already has its bonds and so on? You will remember that the law says that it applies to projects which are placed in service after 2020 and either got an allocation of credits after 2020, which is really obvious, or had bonds issued after 2020. And the bonds issued after 2020 is the one that has caused a lot of confusion. Let me begin by noting that in my experience, the people who write legislation have a lot of trouble with effective dates. And in this case, the effective date portion of the legislation, I mean, everybody knew they wanted a fixed 4% credit rate. The question was, who is it going to apply to? And you will remember that this is one of those things that sort of changed the final weekend before the law came out. And they wrote something which used the word any 4 times. If you have any bonds which finance any portion of any project, I can't remember what the fourth any is, then you are eligible for 4% credits. And that sure sounds like a very loose standard. That sounds like you could have $1 worth of bonds that are post 2020 and your project should qualify. Nobody has interpreted it that way. There seems to be a universal knowledge that it was intended to be prospective and not retroactive, if you will. Of course, what does the word retroactive mean? But in any event, that it was intended really to apply to post-2020 issued bonds. That still gets us to the question of what does the word issued means. Back a few years ago, when they came up with a unfavorable changes to the tax-exempt bond law, a lot of people rushed out and issued new bonds before the effective date of this new law, and then had their money sitting there because they weren't really ready for the money yet. So they had the money sitting there, but they said to the IRS, look, we issued our bonds before the effective date, so we're okay. And the IRS said, not so fast. We are going to interpret the rule that issued means when did you actually draw down the proceeds? Because we're not going to let people get away with issuing their bonds ahead of the effective date. Now we have the exact opposite issue. The IRS issues rules which would be favorable if you're issued after a certain date. And so people say, gee, IRS, last time you told us that our bonds weren't issued until after we drew them down. So this time we're going to take the same position. Even if we issued bonds in a common sense way back in 2019, if we still have some money that we haven't drawn down yet, aren't we okay? Nobody thinks Congress wrote it with that intention. This is a pretty technical interpretation of the word issued. And secondly, nobody is prepared to go there. Now, you will find those of you who are active also in the bond marketplace as compared to the Section 42 marketplace will find that there are lots of bond lawyers who, knowing this rule that I just described, are happy to tell you that your bonds are not yet issued if you still have money to draw down after 2020. But I am not aware of any, and I ask people on a regular basis, so we have a sort of a cadre of us who get together. I ask people on a regular basis, I'm not aware of anybody who is prepared to take the position that bonds which were issued in the conventional common sense way, but which still have money waiting drawdown, so-called drawdown bonds, will qualify for this purpose. People pretty much think that you have to have literally issued your bonds after 2020 in order to qualify. That brings us nonetheless to a second question, which is all those any's in the effective date legislation. Can we take the position that a project which had any bonds issued after 2020 would be okay, even if it had some bonds issued before 2020? And I have pushed the angle of that the word any should be interpreted to mean at least 5%. That you should have some real need. You should be able to show a cost overrun, or, we had a pandemic, let's face it. There are reasons why you have a need for additional money, and that you otherwise complied with the bond rules and found a real third-party bond purchaser. So not necessarily that you just managed to, issue bonds by having the developer buy the bonds, but that the person who otherwise bought your bonds, or you went into the marketplace and sold bonds. And it seems to me that if you do those 3 things, you should be able to say, I have any bonds issued after 2020, I'd be okay. So far, I have had a couple of projects which considered that approach but have not gone forward. But I today heard of another firm which has one project like this, and it apparently is going forward. They have not yet issued the opinion, they have not yet closed the deal, but apparently everybody's on board at this point. So we may be seeing perhaps a change in what people are willing to do here. I will observe that there are a couple of other places where this arises. We have what I might refer to as straddle situations. A project which is used was acquired prior to 2021 and placed in service because it was used. And now we are rehabbing it, and we're going to do the rehab where we spend enough over a 2-year period to qualify for new building credits. And as you know, under Section 42, those are treated as two buildings. There's the acquisition as a building and the rehab as a building. And if the rehab is financed by bonds issued after 2020, and it is placed in service after 2020, then it seems that we have two buildings. The one which you acquired before 2021, that one is only eligible for 3.1% credits or whatever the floating rate is. And the one which is the rehab that you're placing in service post 2020 with bonds that were issued after 2020 seems to qualify for a fixed 4% rate. I have written such a letter to a state agency. We're still in process at this point, so I can't tell you, whether it's been accepted, but it appears that it'll be accepted. I mean, we think it's pretty likely that they'll go forward. The final observation here is this is one that you really do have to work out between investors and developers. There's a fair amount of the investment community that perceives that they can get projects that are entirely post 2020, so they don't have to worry about this issue. They can get all those that they want, and therefore, why would they want to buy into one which is simply increasing the credit rate on an already existing project? And so, there's some merit in that. A lot of people are conservative. And so you really have to sort of feel out your investor and between developer and investor and work out whether or not that makes sense. I mean, obviously there are, lots of relationships here. There are investors and developers who want to work together. There are certainly state agencies. At this point, California and Georgia, I believe, have said, until there's guidance, we're not doing anything on anything which has a pre-2021 bond, even if you try to do something post-2020. Michigan went in the complete opposite direction and said, write us an opinion, we'll do whatever you want. I haven't seen people taking them up on that either. And then I have heard of other states which are sort of open to, to listen and to see what there is. So it is very much a matter of getting the developer, the state agency, and the investor all on board. If you are a developer, don't forget, you do have to have some confidence that this is going to work. Nobody is going to let you do this without expecting an indemnity. And if we are talking about 0.9% on 4%, that's a pretty serious indemnity. You're indemnifying on the order for a quarter of the credits. So, that's one other thing to take into account. And I apologize, I don't remember who I am passing off to.
No problem. I think it's my turn to chime in. So thanks for it. I wanted to take a couple of minutes and describe for folks a couple of opportunities that are out there to receive new PBV contracts, 20-year contracts on a specific set of deals without digging into Public Housing Authority's pool of vouchers, but getting those directly from HUD. Before I do that, I just wanted to take 1 second. We work on a lot of transactions with project-based Section 8 contracts involving acquisitions, rehabs, and renewals under Chapter 15. A few weeks ago, Asset Management issued some guidance on those deals on how the environmental work will be processed. So for anybody on this call that works on those deals that doesn't know what HEROES is, you're about to get to know HEROES really well, and I'd be happy to talk to anybody about how that works and our experience over the years as this has sort of crept up on us. It's now in full force and effect, and it's coming to a Chapter 15 renewal near you. So, but let me focus on the topic of new PBV contracts. There are a couple of sets of properties out there where, based on some fairly recent updates to guidance, it's now possible for owners to get new 20-year PBV contracts, again, directly from HUD funds rather than from the PHA's pool of vouchers. This applies to both the sort of first set of Section 202 transactions, those that still have a loan out there to be prepaid, and also to a set of properties that HUD refers to as at-risk properties. Let me talk about those briefly in order. So first of all, the 202 program, I think Kathy's going to get into this in a little more detail, but was implemented by HUD, as you may know, in basically 15-year chunks, and every 15 years or so, the program changed somewhat significantly. In the first 15 years or so of the program, before 1974, 202 projects did not receive any subsidy for residents. You got the loan and rents were restricted, but no residents were subsidized. And for owners that are prepaying those loans, there's a handful of them out there still, there's an opportunity to get protection vouchers for residents and to make those directly into a PBV contract. We're working on a couple of those where over the years, the owner was able to obtain LIMSA funding, so there's some project-based Section 8 in the deal. But even in those deals, the unoccupied units can qualify for this. Again, this requires prepayment, and that typically does require HUD consent. That's a process with HUD's headquarters office and recap that we've been going through on a number of properties. And the prepayment needs to occur. It can't be a loan maturity. But let me use that to bridge over to the other set of deals, which is the at-risk properties. So each year, Congress has appropriated money for tenant protection vouchers, and in recent years has set aside $5 million for properties that are at risk, meaning that either a loan is to be prepaid or use agreements is coming up on its expiration, and as a result, the protections in place for residents to keep rents affordable for them are going to go away. And for some of those properties in low vacancy areas with at-risk residents in them, again, you can make an application to HUD. This would go through the field office and receive vouchers, and those vouchers can also be taken by the owner directly as a PBV contract. Now, again, it's a limited set-aside. It's on a first-come, first-served basis. It only applies to properties in certain low vacancy areas. You need to have a qualifying trigger event. So that includes certain loan maturities, including a 202 if that were to mature rather than be prepaid. Certain use agreement expirations. And so I've been involved in a deal here recently where the 236E2 use agreement burned off. Residents had not been protected up until then. After that agreement went away, made an application for vouchers, and residents, about a third of the project residents in that case, are now able to receive vouchers, and that's a new PBV contract for the owner. So it's an opportunity, that you may, well, the one thing I wanted to point out in connection with that example is with respect to these at-risk properties, there's a look-back period. So if you have a deal where a HUD use restriction burned off in the past 5-year period, or a loan matured, particularly a 202 or a 236 loan matured in the past 5 years, there's an opportunity to make an application for up to 5 years after that occurred and to qualify to receive these vouchers. Again, potentially an opportunity for a new PBV contract. And once the contract's in place, it functions like any other PBV contract. So administered by the PHA, it can come into the project immediately at the time of this qualifying event. There's no need to do an AHAP first. It's got a 20-year term. Rents work just like any other PBV contract at the payment standard, which can be up to 110% of FMR. So it can be a great resource and really something that can enable preservation of a deal, rehab, protection of these at-risk residents. And we've been doing a number of transactions more and more in recent years involving this source of funds. So that's a high-level description. There's certainly a lot more to say there, but I don't think we have time for it today. So let me turn things over to Harry Kelly to talk a bit about what the Biden administration is up to in the area of fair housing.
Thank you very much, Nate, and good afternoon, everybody. Thank you for taking some time today to join us. As Nate indicated, I'm going to talk today about what's been going on in the area of fair housing. There's been a lot of turmoil in this area over the last 10 years, and it continues into the new administration. Since the Biden administration took office in January 2021, it has aggressively pushed a strong fair housing agenda, which is part of its overall, for lack of a better term, equity agenda, which looks at fair housing and housing opportunity as an important part of economic opportunity in general and responding to racial justice issues as well. Most of the Biden administration's effort is focused on rolling back several efforts initiated by the Trump administration that in turn sought to restrict fair housing initiatives begun by the Obama administration. So I'm going to summarize several aspects of this rolling back of the rollbacks, if you will. The first is in something called Affirmatively Furthering Fair Housing, shortened to AFFH. That's a mouthful, but what it means essentially is that under the original Fair Housing Act, HUD and other federal agencies had an affirmative duty to try to promote the goals of fair housing in a desegregated society. Eventually, that duty was expanded to other state and local grantees, state agencies, local PHAs that received assistance from HUD. There was a lot of feeling that the original program, as it was designed, did not encourage these agencies to firmly deal with what the obstacles to fair housing were in their local areas and lacked teeth to hold them accountable so that they take concrete steps to improve things. In response to problems with the original AFFH rules, the Obama administration overhauled those rules back in 2015, required grantees to take more aggressive steps to eliminate local barriers, and in addition, it imposed some enforcement or financial tools so that HUD could have some teeth to hold them accountable if they didn't do what they were supposed to do. There was a lot of pushback from local grantees. A lot of them said, we don't know how to do some of the things that you want us to evaluate, such as where employment opportunities were going to arise, or who needed better health care, or what transportation issues were involved. And they also resented, frankly, a lot of what they perceived to be top-down instructions coming from HUD in Washington. So last year during the presidential campaign, the Trump administration significantly curtailed the scope of those 2015 AFFH duties by repealing those rules, and in fact repealing the original rules. And basically the Trump administration said that merely preserving existing affordable housing would be sufficient to meet local agencies' affirmatively furthering fair housing duties, and nothing more would be required. President Trump vigorously promoted this initiative during his campaign, saying that essentially he was making the suburbs safe from affordable housing. And needs to say, the Biden campaign was equally vigorous in opposing those moves. When the new administration took office earlier this year, they announced that they were going to reinstate the original Obama-era rules, excuse me, but without the reporting requirements that had upset so many of the local agencies. Why is this important? Well, AFFH is one way that HUD and third parties can try to hold local governments accountable and try to encourage them to develop and promote more affordable housing in their areas by doing things like removing exclusionary zoning rules. So since the new reporting requirements have been removed from the AFFH rule, it's not clear what teeth are left into it. And it will be interesting to see whether and to what extent there is a significant improvement in local grantees' performance in this area. Next topic, disparate impact. What is disparate impact? Disparate impact is a theory that holds that a housing provider can be held liable to violate the Fair Housing Act if it adopts policies or practices that, although they don't look discriminatory in their face, nevertheless have a harsher impact on protected classes, and even if there's no evidence of intent to discriminate. Because it doesn't require evidence of discriminatory intent, disparate impact can open up a broad range of forms of liability for actions that an owner took in good faith without any intent to discriminate against anyone. In 2013, HUD announced its new disparate impact rule, which included this sort of what they refer to as burden shifting mechanism, where the plaintiff had to show certain facts, then the burden was shifted to the defendant to make a defense, and then finally come back to the plaintiff to show that there was no that there were other alternatives that were available. In 2015, however, the Supreme Court, in a decision called Inclusive Communities, while it confirmed that disparate impact liability exists under the Fair Housing Act, it also indicated that it wanted to impose certain what are referred to as safeguards to prevent abusive disparate impact cases, including that the challenge practice had to demonstrate that an arbitrary, artificial, and unnecessary burden was being placed on housing opportunities. Beginning in 2019, the Trump administration tried to revise the original disparate impact rule to incorporate some of these concepts from the Inclusive Communities decision. That original proposal from 2019 was pretty modest in scope, but again, last year, HUD published a much more radical revision to the regulation, essentially requiring a disparate impact plaintiff to satisfy all of these safeguards at the original pleading stage, which is very early in any litigation case. If adopted, that rule would essentially made it impossible for anybody to ever show a disparate impact case exists. Earlier this summer, HUD published a notice saying that it was repealing the 2020 disparate impact rule and reinstating the original 2013 rule. But the truth is that, however, that 2013 rule doesn't address what the Supreme Court said, and that the 2020 rule went way overboard. So hopefully there's some kind of middle ground, and right now there's a comment period that's open, during which I hope some suggestions will be made to bridge this gap. Final two topics, assistance to mixed families and equal access for transgender persons. The Trump administration also published proposed rules to impose limits on assistance to mixed families, that is, families that contain, on the one hand, U.S. citizens and legal documents, legally resident persons, as well as undocumented persons. And it also proposed rules to make housing choice less available to transgender persons in homeless shelters, partially responding to people's concerns that the rules from the Obama administration imposed on the religious belief of many operators of homeless shelters. The Biden administration has announced over the last couple of months that it's withdrawing both of those proposed rules, so they aren't going to go forward, and presumably, at least for the coming years. So to wrap up, there was a lot of consensus for a long, long time about what fair housing meant. That consensus has sort of unraveled over the last 10 years, and it is unfortunate that fair housing has become such a politicized matter. But it's possible that by tackling some of these matters early in the administration, the Biden administration can get some policies in place which will allow less of this sort of ping pong that we've seen over the last 10 years, and hopefully provide more stability for courts and agency officials and for all of us in the regulated community. And that's where I'm going to stop, but we have saved the best for last, because the next speaker is Kathy Soroka, and she's going to talk about RAD for PRAC. Kathy.
Excellent. All right. Thank you. Thank you, Harry. And thanks everybody for sticking with us. They brought me in as the closer. So if you're multitasking, get ready for a ride. We're going to talk about RAD for PRAC. We've had let me see if I can advance the slides. Nope. Okay, Scott, can we move to the next slide, please? Oh, okay, great. Okay, so as Nate mentioned, the RAD for PRAC is a subset of the tools that are available for the 202 program. We may quiz you later on the different tools, the differences between what Nate was talking about and what we're talking about. But as a refresher, what we're talking about now are the PRACs, the Project Rental Assistance Contracts, for the 202s that were Section 202 loans that were provided through capital advances in the period starting at about 1990. So the first period of 202s, as Nate mentioned, didn't have rental assistance attached, but you've got those prepayment tools, which are a way to preserve that property. The next cohort of 202s, it received PBRA contracts, so those are fantastic. Don't touch those. And then the ones from 1990 got these project-based rental assistance contracts that need to renew annually. They're stuck on budget-based rents. They don't always take into account replacement reserves. So those are a growing problem, and the RAD RAD for PRAC became a solution, a tool that we have there. So next slide, please. The basics, just like the rest of the RAD program, you get a 20-year renewable HAP contract when you convert from RAD. The rents are, again, unfortunately, like most of the rest of the RAD program, shockingly low, but there are tools to try to increase them, which we will talk about. So the rents are based off of the existing PRAC rents. You do have an ability to increase, but the surplus cash is available to you from the project. You now have an ability to take distribution, so you are incentivized to manage these projects well. The capital advance documents and those restrictions will be eliminated, and a new RAD use agreement will come into place. You have the ability to choose either PBV or PBRA, but for the love of all things holy, choose PBRA. We don't have the time today to get into why. If you're interested, please give me a call and I will be happy to share with you the many reasons why you should choose PBRA. Go ahead, Scott. In a nutshell, the process for converting to RAD is set out on your screen now. We start with a submission of interest to HUD. HUD calls it a letter of interest. It is, in fact, not a letter. On the RAD resource desk, it's called an application. It is, in fact, not an application. So it is a brief submission of interest where you put in basic project info. That kicks off HUD's awareness and starts the process for you. There is a resident consultation requirement, as there are with all of the RAD components. And big in the RAD for PRAC process are the BBRI process to set your PRAC rents. PRACs are, as I mentioned, renewed annually. They are renewed through the budget-based rent increase process, sometimes called rent adjustment, BBRA. You do that annually. You would do that in order to establish the rents that you will get for your project that would then carry over through the conversion. There are two pieces to that: the expenses portion and the needs assessment, and we'll talk about that when we talk about more detail about setting the rents. You then, once you get your rents, you're able to establish your financing, underwrite your deal, put together your scope of work, do your environmental review, and a whole bunch of other stuff that gets put into your conversion plan and submitted. At that point, HUD has about 60 to 90 days where they will review that conversion plan, potentially ask you a number of questions. Then they will issue you a conditional approval and you are off to the closing races. There is a draft conversion agreement that you will sign at closing. That's where us lawyers like to geek out on those contracts, dive in, get all your good details set up. And then once you close and rehabilitate the project if necessary. So you can see between all these steps, that the rent setting and the conversion plan and HUD review and then closing and then HUD review and then closing, the submission of the closing process and then the HUD review and then the actual closing. It's a long time. You should pretty much think about a year for this, although it can be significantly faster, but it can be significantly longer. So keep that in mind. Next slide, please. As we said, your rents are limited to the lesser of approved PRAC rents or 120% of FMR, which is 110% for the PBVs, one of the many reasons why you should choose PBRA. And setting your rents for the RAD conversion is a bit of a dance. You have to set your rents as if you were continuing to do the PRAC, run the PRAC as a PRAC, even though you're not going to do that. Even though you're going to convert it and HUD knows you're going to have a scope of work and you're going to have a recapitalization event, you have to set your budget as if you were continuing to run it as a PRAC so that HUD can grant you that rent under their statutory restrictions, and then you'll do that, the conversion. Next slide. again, because you're doing that dance with the rents, you want to find a way to maximize those rents. You can't say, I need training for my staff for LIHTC compliance because we're doing a LIHTC deal, because you can't do a LIHTC under the PRAC, right? So you can't say, I need to include my debt service, because you can't include debt service under a PRAC. What you can do is, here's my needs assessment, and I need a replacement reserve. If I'm not going to do a recapitalization event in this hypothetical universe where I'm continuing to operate this as a PRAC, I'm going to need a replacement reserve so that when the roof gives out in 5 years, I will have the money available to fix the roof. Again, it's a bit of a dance. HUD knows that you're not going to do that, but there's always another way to get there, and that would be a legit way. If RAD didn't exist, you would need a replacement reserve. So that's the #1 way to boost your rents. You also want to make sure that you're accounting for social services. It's a requirement of the program. You want to make sure you're actually including all of your costs. You may get a bump for utilizing small area FMRs, and you can get an extra bump for social services at closing. Next slide, please. For the conversion plan, as I mentioned, there's a whole bunch of stuff that goes in there. Here's your list on the screen, and again, it's the kit and caboodle. You're putting your deal together. You will submit your needs assessment with a scope of work. You've got to do your environmental. You're going to need your budget, your sources and uses, and all that good stuff. There is a nonprofit organization involvement requirement and a social services requirement. Most RAD conversions are not new construction, but if they are, be careful for FHEO site neighborhoods. Next slide. Good to know, in a PRAC, you actually, in the RAD conversion, the seller can actually use a portion of the proceeds. This is debatable under the transfer of a 202 PRAC as a PRAC. It is debatable whether the proceeds would be restricted. Under a RAD conversion, if you have a third-party transaction, and the budget allows for proceeds, that seller can utilize what HUD refers to as the equity under the deal. That is the percentage of the capital advance term that was completed times the original amount of the capital advance. If the capital advance was 40 years and you have gone 20 years, that is 50% of the original term, you can take 50% of the original capital advance amount. If it was $10 million, you get $5 million unrestricted. Doesn't mean you get $5 million. It means that if the budget allows for that amount of equity, the seller can take it unrestricted. Next slide, please. Other key features, Davis-Bacon does not apply. We mentioned the nonprofit involvement requirement. We mentioned the capital advance documents are going to be replaced with the use agreement. And we mentioned that supportive services are required. Next slide. Thank you. I will now bring it back to Nate so that we can take your questions.
Great. Well, thanks, Kathy. And thanks to all the presenters. And just a reminder that this call was recorded, and you should be receiving a copy of the recording here in the next few days. So if you want to study Kathy's slides in more detail, or if you want to watch again, you should have an opportunity to do that. So we do have a couple minutes for questions. Let me lead off and ask Forrest a question that we received before the presentation. Forrest, another topic that folks are interested in is the 50% test. And there's been discussion of reducing that from 50 down to some lesser number. What's the latest on that thought process and whether and how that might happen? And I think you'll need to unmute.
There are a variety of proposals in Congress that would expand credit authority. In fact, credit seems to be the hot new way to do things. In the past few days, I've seen middle income credits, and I've seen revitalized downtown areas credits, and there's a variety of things in various other tax equity fields. In our field, in the housing world, the notion of expanding the availability of 4% credits by saying that instead of having to have a project which is 50% bond financed in order to qualify for the full 4% credits, you only have to be 25% bond financed, has been something that's been in the hopper for a little while. It has shown up in several places. It has shown up in the bill, which is being pushed by the Affordable Housing Tax Credit Coalition. It has shown up now in Senator Wyden's new proposal. So it's in a lot of places. It is also, in my experience, in the various agencies which are pushing credit proposals and recognizing that they may not be able to get everything. This one seems to be way up at the top of the list. The two that are at the top of the list are the 25% bond financed and increasing the availability of 9% credits for a short period for 2 to 3 years. The one thing that most recently came up was also just questions about, for how long can we get this permanent? Might it have to be a phase-in kind of thing? But I would say that of the things that we are hearing about, this is probably the one that the industry, this is way up there, that the industry is really hot to get this. So I would say it's very likely to survive all the way to the end.
Excellent. Let's see. I see some questions in the Q&A here, and feel free to throw more in there, although we've only got a minute left. So, but I'll say, also feel free to reach out directly to any of the panelists here. This is what we love to talk about. So happy to take your questions outside of this webinar as well. But yeah, I see one that's been answered. What's the HUD code section that governs the at-risk properties? So that is under the HUD Appropriations Act, as well as some notices that HUD has published on how those will be implemented. I don't have time to go into that in great detail, but happy to talk about that further outside of this as well. So I'm seeing some other questions. We'll probably have to get to those offline because we're at our time. But thanks to everybody who joined. Thanks to everybody for sticking with us right to the end here. And look forward to connecting with you all again. Thanks so much.
Thanks, everybody.
Thank you.